To the Maryland Public Service Commission. This is our hearing in docket number RM76 with respect to staff's proposed new regulations regarding cybersecurity. By notice issued on March 3rd, this is the time and place for the Commission to consider these proposed regulations. We will begin today by taking appearances of the parties, beginning with staff. Mr. Dean, your microphone is on mute. Oh, we cannot hear you, although I could read your lips. Okay, Mr. Dean, it looks like you were able to turn your microphone on and off, but unable to hear you. Let's move to Office of People's Counsel, and we'll come back to you. Do not actually see Office of People's Counsel in the room, so we will turn to the utilities, starting with Potomac Edison. Oh, okay. Mr. Trout, I can't hear you either. Perhaps you could hear me. If you give me the thumbs up. Okay, you could hear me. According to us, your microphone is open, but we cannot hear you. One moment while we attempt to troubleshoot.
Okay. Let's see. Speaker system is correct. Microphone array is correct. Mr. Trout?
Yes. I don't know what to do. It's turned on.
I'll stop you right there, sir. We can hear you now, so thank you.
Okay,
You're coming
good.
in very loud and clear. And Mr. Chairman, I believe we are good.
Okay, we'll take this from the top. We'll go back to Mr. Dean. This was a problem on our end.
Good morning, Chairman, Commissioners. Michael Dean on behalf of the staff.
Thank you. We'll return to Office of People's Counsel. Oh, they're still not with us. So we'll turn to Mr. Trout.
Okay. Again, Jeff Trout, Potomac Edison. Good morning. I'm glad we're all able to communicate.
Thank you, Mr. Trout. Loud and clear. Southern Maryland Electric Cooperative. Baltimore Gas and Electric Company.
Yes, good morning, Mr. Chairman. Daniel Herson for Baltimore Gas and Electric Company.
Thank you, Mr. Herson. PHI.
Good morning, Mr. Chairman, Commissioners. Doug Mikeel on behalf of Pepco and Delmarva Power. We also have Joe Quinn from Exelon and perhaps Paul Ackerman from Exelon on the line.
Thank you. Washington Gas. We'll return to Southern Maryland Electric Cooperative. Okay, we see Mr. McDougall from SMECO. We see Mr. Kane from WGL. We can't hear them. So at this point, we'll have them make introductions if they need to participate at a later stage. So, with all of the events occurring in Ukraine and domestically, we've seen our fair share of cyber attacks, ransomware attacks, and other hacks of vital infrastructure over the past year. Of course, the Colonial Gas Pipeline incident last year affected many on the eastern seaboard. The ransomware attack that held hostage the city of Baltimore the year before also crippled a number of very important functions with respect to city services. I understand that the White House actually sent a letter to all 50 governors just last week extolling the need for all industries to protect against cyber hacks, particularly with some of the potential threats coming out of Russia. Notably, Governor Hogan was one of those 50 governors who received this letter from the White House last week, and it had some specificity with respect to state utility commissions. And I would read two of the questions that President Biden posed to the governors because they directly bear on the operations of utility commissions as well as the role of the utilities. The first of these two questions was, have the Public Utility Commission in your state set minimum cybersecurity standards for your critical infrastructure? If not, please ask them to do so. And the second question was, do you or your public utility commissions have the ability to require critical infrastructure to take emergency cybersecurity measures? If so, have you or they required utilities to set up their security in light of the current conflict in Ukraine? Obviously, this commission, through its work with the work group, the cybersecurity work group, has been engaged and attentive to this matter for a number of years. So the staff proposal that was filed earlier this month reflects those ongoing efforts, and I'm glad that we're here to discuss this very timely issue today. As I noted at the outset, on March 1st, the Commission staff filed these draft regulatory texts proposing modifications to our regulations. Interested persons had until March 24th of 2022 to file responsive comments, and OPC staff and Potomac Edison did file comments. I know that the commissioners have reviewed the proposed regulations as well as the responsive comments, and our lead advisor, Trevor Tomlinson, provided the commissioners with individually with a summary of those comments. At this time, I will turn to staff to provide a brief presentation and a walkthrough of the comments that were of the proposal that was filed back on March 4th. Good morning, Mr. Borkowski.
Okay, good morning, Mr. Chairman and Commissioners. John Borkowski for staff. And without repeating your introduction, I'd like to just indicate that the proposed regulations that staff filed on behalf of the work group, the Cybersecurity Reporting Work Group, on March 1st, are applicable to all Maryland utilities under Commission jurisdiction, and they established several cybersecurity definitions, a standard for good cybersecurity practice, requirements for periodic cybersecurity reporting for utilities over 30,000 customers, and also requirements for utility cybersecurity breach reporting. As you indicated, on March 24th, several comments were received. In addition, on March 28th, staff filed an updated set of clean proposed cybersecurity regulations that reflected a formatting change and a change to the proposed COMAR subtitle for the regulations. These were changes that occurred after the March 1st filing. Now, in the March 24th, going back to the March 24th comment filings, no utility opposed the proposed regulations, and OPC filed several comments recommending that the Commission adopt the proposed regulations, but they also suggested revisions and matters for reconsideration. I will defer to OPC to describe their comments, but as the work group leader and on behalf of staff, I recommend the commission approve the regulations that were proposed as reflected in the updated set of clean proposed utility cybersecurity regulations, and I'm available for any questions.
Thank you, Chief Borkowski. At this point, I will open it to other parties to make any commentary.
Mr. Chairman, this is Jeff Trout for Potomac Edison. We agree with staff. We support the regulations as filed, and we do have a reaction to the comments that were filed by the Office of People's Counsel, which we can either give you now or after OPC explains their comments.
Thank you, Mr. Trout. OPC was not with us at the start, but I see Mr. Hoover is with us now. Mr. Hoover, would you like to provide comments and then receive the rebuttal?
Yes, Mr. Chairman. Fred Hoover on behalf of the Office of People's Counsel. As we noted in our filed comments, we do support the regulations proposed by the Cybersecurity Working Group, but we did specifically ask for 3 additional items. The first is that the Commission should task the Cybersecurity Reporting Working Group to consider development of regulations related to the information of personal and financial information of customers that is obtained and retained by utilities. It's our concern that due to the use of advanced metering and as well as the electronic interactions between utilities and customers, utilities are accumulating more detailed information about their customers, particularly the situation where customers have electronic bill payment. They have a direct financial connection with the utility. And we think that because of this increasing amount of information that's retained by the utilities, that there should be some consideration as to whether or not specific regulations should be developed to protect and safeguard that information. Now, it's possible that this could be considered as part of the good cybersecurity practice, but it's our view that a more specific set of standards and regulations should be developed for personal information of customers. Second, we do think that the Commission should specifically require reporting of cyber incidents by third-party vendors of utilities. It's our concern that the suggestion that was made by staff in their filing of comments on March 24th, that material business impact breaches of cyber events involving third-party vendors should be reported when it's reasonable and practical, will actually create enough reasons for these things not to be reported. As was noted in the petition filed by the working group, there were a myriad of reasons why the utilities resisted this idea of having a required reporting of cyber incidents by third-party vendors, some involving the difficulty in getting the information from the third-party vendors, and then secondly, some concerns about contractual limitations. It's our concern that those types of reasons will be cited by utilities for not being able to file incidents regarding cyber incidents with third-party vendors as being not reasonable and not or practical. And it's our thought that this information is a vital part of the Commission's vigilance over the information and operation networks of the utilities from the threat of cyber attacks that could occur because of an unauthorized access of the network of third-party vendors. It's not our opinion that this should be a blanket across the board reporting of all cyber incidents involving third-party vendors. We think that the working group can go back and take a look at the current arrangements with third-party vendors and look at specific situations where there's more direct involvement between the third-party vendor and critical operations of the utility or direct interface with customers And those situations may be the ones that require reporting to the commission. And then the third suggestion we made was actually uh, increasing the frequency of the reports. Right now, the audits call for a 3-year cycle. It's our thought that maybe that should be cut to 2. And this is really in reaction to the situation that has been occurring because of events in Europe and the heightened concern on the part of the federal authorities about possible cyber attacks from nation states. It's our thought that the more frequent review of the proactive operations being taken by the utilities, by the potential threats caused by these groups that want to do the harm to a critical system affecting the state is in the interest of both the commission, staff, and the parties involved in this proceeding.
Thank you, Mr. Hoover. We'll turn back to Mr. Trout.
Thank you, Mr. Chairman. So OPC makes 3 recommended changes. Respectfully, we are skeptical as to the third and opposed to the first 2. With respect to the first one, which is customer information protection, that's a much broader topic than just a cybersecurity issue. And as the commission is aware, it is a topic that the commission has been running a working group on already for several years in PC 44, the customer choice work group led by Mr. Chen. And in fact, this very topic is being discussed tomorrow morning in a meeting of that work group. So we would suggest that bringing in the cybersecurity work group to look at one aspect of that larger topic several years after the commission's examination of that topic began is unproductive and not a good use of the cybersecurity work group resources. With respect to third-party breach reporting, we thought staff's report, the work group report, stated the situation very well. When such breaches do impact the utility systems, the existing rules require us to report that, and we will. And otherwise, if they don't impact the system, OPC would have us chasing around and reporting to the commission on stuff that at the end of the day is not material to the commission's mission and to the utility service to its customers. So we think for the reasons laid out in the work group report and further articulated here, that is, again, not a good use of the cybersecurity work group team's resources. To OPC's third point, the frequency of having the briefings in front of the commission, we're skeptical of that because we think the current 3-year cycle is working fine, and we heard absolutely no discussion during the work group meetings of making any changes to that cycle. Nonetheless, Potomac Edison acknowledges that the frequency with which you ask us and the other companies to come and report to you is entirely addressed to your sound discretion. So we will do whatever you all want us to do with respect to that. We just believe that, one, that was a topic that if we were going to make a change, it ought to have been raised during the work group. And 2, we believe that the current cycle is working fine. That's what I have for responses, and I'll yield the floor unless anyone has any questions.
Thank you. Mr. Trout, I believe commissioners will have questions on these topics in just a moment. Let me first see if there are any other parties that wish to make initial comments.
Hi, Mr. Chairman. It's Dan Herson for BGE.
Mr. Herson, good morning.
Good morning. couple points I wanted to make. First, I know the Exelon utilities did not submit any comments after the submission of the work group's proposed regulations, but for the record, I wanted to let the commission know that we're fully supportive of the regulations as drafted. As a work group participant, we had input in the drafting of that report, and we support what Mr. Borkowski submitted to the commission. We think that those proposed draft regulations adequately cover the concerns, both given the current heightened cybersecurity risk environment as well as the OPC concerns. We echo Mr. Trout's points. I think that the third-party reporting issue is adequately covered by the proposed draft regulations. We also think that the triennial reporting has worked well. We provided our initial report back in 2019. We're scheduled to provide another report later this year in 2022. And as the proposed regulations indicate, the commission has the discretion to ask for more frequent reports as necessary or as they request. I'd also like to point out, because I'm not sure it's been pointed out, that there's already existing law in Maryland under the commercial law article. It's section 143504 that requires notifications of security breaches to the Office of the Attorney General. And I know that with respect to the utilities, or at least the Exelon utilities, in the event that we've had an obligation to make such a report to the Attorney General, we routinely also report to the Commission. So given what's already on the books in Maryland law and given the flexibility that we think that the proposed draft regulations provide, I personally believe that all of the concerns that have been raised are covered, and frankly, the flexibility of the proposed regulations, I think, is a plus. We see a lot of changes in this area. The risk profiles change almost weekly. There's heightened risks, and then it might become a little bit better for a while, and then there's different threats that emerge. And I think having some flexibility, which we believe the proposed regulations provide, is actually a benefit to the commission and the parties, and it allows everybody to address threats as they emerge. So we're happy to take any questions you have, but I just wanted to provide those comments. Thank you.
Thank you, Mr. Herson. Hearing no additional comments, I do agree with Mr. Herson's last point that while these regulations are rather brief, only 2 pages, they are broad and flexible, and it's my intention that these regulations are only a first start with this new subtitle 6 being built out with additional time and additional work of both the cybersecurity reporting work group as well as Mr. Chen's CCMC work group, as was noted, will be meeting tomorrow morning. I'll turn to my colleagues with any questions, beginning with Commissioner O'Donnell.
Thank you, Mr. Chairman. I have a question for Mr. Hoover, and then at the appropriate time, I may have a couple questions for staff. Mr. Hoover, during your point on third-party reporting, repeatedly you used the term, and correct me if I'm wrong, reporting of incidents by third parties. And I want to clarify that recommendation because I don't think we have any jurisdiction over those third-party suppliers. How would we enforce their reporting if they're non-jurisdictional to the Public Service Commission?
Commissioner, your transmission actually was kind of garbled, so I didn't actually pick up.
Well, let me try to clarify so that we can make sure you heard what I said.
Mhm.
I don't think third-party suppliers are jurisdictional to the Public Service Commission. How will we enforce them to report to us?
Well, so what our proposal would be is that when the utility is made aware of a breach by a third-party vendor that they're engaged with, and this was the discussion that came up, during the work group and is reflected in the petition, that when they become aware of those breaches, that they should be required to report those breaches that have a significant impact on either their direct operations or impacts on their customers to the commission. And so, what I've heard earlier today and what was in the petition was that, there's limited reporting of this that would be uh, undertaken, but it's our view that there needs to be a little more stringent requirement on the utilities as to the reporting that ought to be done. Now, that being said, we're perfectly willing to go back to the cybersecurity work group and work out the details on what types of incidents and what types of vendors should be required to report. As we said, we're not saying that every incident involving a third party vendor should be reported, but we do think a more stringent requirement on the utilities to report breaches involving their third party vendors is necessary.
So I'll accept can you hear me?
It's still sort of kind of garbled, I guess is the best way to describe it. So,
How about that? Is that better?
a little better, yeah.
Okay. We're getting mixed messages here today. We got to eat the microphone or we got to back up. So I'll accept your explanation there, and I'll write it off to syntax that when you were saying reporting by third-party vendors, and you said that repeatedly, you really didn't mean that. You meant reporting by the utilities in an
Yeah, we
expanded
want
fashion.
utilities would report the breaches that occur affecting their third-party vendors. So it's not the third-party vendor making the report to you.
I just wanted to make clear on that because that's not what you said. So I just want to clarify your language.
Okay, well,
Okay.
that is our intention. That
Okay,
it's
good.
reporting by the utility of breaches involving their third-party vendors.
So, but anything that has a major impact on utility operations or customer information or otherwise are already required to be reported by the utility, correct?
And I guess the only concern we have is that during the work group discussion there was a lot of reporting by the utilities about the difficulty in obtaining some of these reports, that the third party vendors may be reluctant to tell them exactly what's going on. There may be contractual limitations, and so we're concerned that just doing this when it's practical and reasonable may not be a strong enough requirement on the types of incidents that may have significant impacts on utility systems that are critical systems for the state.
Well, what do you say to Mr. Trout's point that the utilities may be chasing breaches, cybersecurity breaches that are not impactful, and they're trying to chase every little thing down because some spearfisher tried to get into the third party vendor and blah blah blah. What?
Which again is one of the reasons why we suggested going back to the working group and having them examine in more detail the third party vendor relationships that currently exist with the utilities, what types of information involvement they have with the utilities, and then that way develop a limited set of circumstances when these reports would be required. So we're not saying every single breach that occurs with a third party vendor that a utility deals with needs to be reported, but those that impact significant operations of the utility or maybe have direct interface with customers, those situations probably should be reported.
So, when you're suggesting to go back to the work group, are you suggesting we not act on these regulations today and delay them further?
No, we're perfectly happy with you adopting the regulations that were proposed in the petition. We think those regulations are sufficient. We just think that an additional task to the work group is another examination of this issue about the third party vendor situation, and then the second the other two ideas, which is looking at the personal information. I understand Mr. Trout's comments about the other working group dealing with that, and the third one related to the increase in frequency of the reports really became a result of situations that happened after the work group stopped meeting, and as these petitions were being developed. That's when the situation in Ukraine developed, and that's when this heightened concern on the part of the federal government occurred. So this is a fairly recent occurrence, which has caused us to think that maybe more frequent reporting by the utilities to the commission about what's going on is a prudent action to take.
Thank you. I'll have questions for staff when it's time, Mr. Chairman.
Miss-
Commissioner O'Donnell,
Oh.
it's Paul Ackerman at Exelon Corporation, Associate General Counsel. Would it be possible for me to just address one point raised by the People's Council?
Sure.
Yeah, I think the concern we raised about being able to get information from our vendors was directly related to the point that you made, that these vendors, we deal with thousands of vendors, particularly when you're talking about our IT systems, which go into our corporate and business systems as well as operational. There are, the fact of the matter is there are an increasing number of DDoS attacks, spear phishing attacks, things like that. And we, if those attacks have no impact on our systems or on our information, we don't contractually, we do not hear about them unless there is a risk to our company. And we do mandate that reporting. And in turn, under the existing regulation and previous under the commission's order, which led to this regulation, we have routinely been reaching out and reporting on instances where vendor cybersecurity incidents ended up posing a risk to our systems or our information as it's defined now in the proposed rule. If you look carefully at the proposed rule, it includes the disclosure of information. So if a vendor's has malware or has some type of breach that reaches out in a way that impacts us, we are reporting that to the commission. We have been, and we would continue to under this rulemaking. Thank you.
Thank you, Mr. Ackerman. That's helpful.
Mr. Hoover, we addressed one of your three issues. I'd like to address another one. This was actually the first issue that you raised with respect to developing new standards to protect the personal data and information of customers. You noted that the relationship between the utilities and customers has changed more recently. Can you elaborate a little more? I know you just mentioned a few minutes ago with respect to bill payment. Although customers have had the ability to pay their bills automatically through a credit card or EFT transaction for probably 20 or 30 years. And do we not already have regulations and laws on the books to require that the utilities guard against the disclosure of personal customer data?
Well, what we're looking at is the fact that the relationship between the utility and the customer is getting more and more integrated, not only from the electronic bill payment that a lot of customers are using, but to the extent that, through the use of AMI and other programs and incentives, the utility is now looking at managing energy systems in people's houses and businesses and things like that. And so therefore, that's bringing into the utility a lot more information from the customers, other than the old days when it was just how much you used and how much you get charged for it. So it's our thought, and we noticed that in the piece of legislation that was filed in the General Assembly regarding this, there was discussion in that bill about having more detailed examination of the personal information of customers that was retained by utilities, and the suggestion that the commission consider regulations for that. So it's our thought that this is a subject that again should be taken a closer look at. Now it can be done in conjunction with the other working groups, but just to make sure that the cybersecurity aspects of the personal information that is obtained from customers is reasonably protected, either under the PC44 work group or the cybersecurity work group, and maybe the two can work together.
I recognize that the utilities probably do have more information than they did on their customers 10 or 20 years ago. And I recognize there was also a bill, I believe it was reported on favorably, that would have touched on these issues during this legislative session, although I believe that bill is not going anywhere at the moment. I'm not particularly convinced that the regulations and laws that we have need to be changed at this time based on the utility's track record of maintaining personal confidential information of its customers. Let me turn to that last point that you had with respect to the cadence or frequency of which we have these briefings with the utilities. The People's Council does recognize that the language is at a minimum every 3 years, which means that we could, if necessary, have the utilities before us every 6 months if we wanted to. Does that address your concern, the language at a minimum?
To a degree, but I think the concern is over the fact of the sort of heightened peril that is probably, from the cybersecurity threat. I mean, one of the from experiences I've had in this field, the federal authorities are convinced that a cyber attack against essential utility systems, whether it's natural gas, electricity, or whatever, is going to be the act of either a terrorist group or a nation state. And it's designed mainly to cause social disruption and chaos as opposed to extracting money, which the ransomware people do. So it's our thought that given the heightened international situation regarding the war in Europe and the fact that the federal government is concerned about cyber attacks by nation states against the United States and against the states, based on that letter that the president sent to the governors, it's our thought that a more frequent review of cybersecurity threats might be a prudent action. As was mentioned, the difference between the resiliency and reliability concerns related to weather events, we sort of know what the events are. It's hurricanes and tornadoes and things like that. The cybersecurity threat is a constantly evolving threat situation where the people intending to do harm are always looking to counteract protective measures that are taken to safeguard the utility information and operations systems.
Well, Mr. Hoover, I understand these bad actors are getting more sophisticated every day. So would your argument then be we should have these reports every year instead of every 2 years? How did you land on 2 years?
Yeah, we landed on 2 years. So I mean, it's a suggestion of more frequent. I mean, and as you said, the commission has the ability to order more frequent briefings. I guess it's just our suggestion that as a practice, let's start that more frequent briefing by going from 3 to 2.
Okay. I would respond and just state for the record that the commission is reviewing annually a number of utilities who are required to report per the schedule. So it's not as if, and I know you're not implying this, it's not as if we're waiting every 3 years. This is a rolling basis. And of course, if the utilities, also incumbent on the utilities is the responsibility to let us know if these reports should be filed more frequently. But at this time, I personally feel that 3 years, a 3-year cycle, at maximum or at worst is appropriate, and the commission could always call the utilities in on a more frequent cycle if the situation warrants. Thank you. I'll return to my fellow commissioners. Commissioner Herman.
Thank you, Mr. Chairman. I have a question. I'm going to try it with Mr. Dean and see if I can get my question answered. If not, maybe I'll turn to Mr. Chen as the work group leader. Mr. Dean, I'm looking at O2B3, the definition of information technology system. Let me know when you're with me there. Mr. Dean, are you with me? Well,
could you repeat your question?
Sure. I'm at O2B3. Are you with me?
Yes.
Okay. So and I think that this does not require a republishing or anything else, but it says that IT system means hardware, software related to electronic processing, comma, and storage, retrieval, transmission, and manipulation of data. I assume you mean that electronic processing of data, or is it just electronic processing? Because that comma is a little confusing to me.
Mike, I'll address this question if you'd like.
Oh, thank you, Mr. Borkowski.
Yes, Commissioner Herman, the information technology system definition carries over from the discussions we had in case 9492. We have not modified it, but I consider it or interpret it to be electronic processing in general, and the manipulation of data is also covered later.
Okay, so that comma is not is just electronic processing of anything, and then the other parts relate to of data.
Yes.
Okay, thank you. I just wanted to make sure that that was what we intended. Thank you very much. And I will say, since I have the mic, and hopefully people can hear me, that I believe I understand and appreciate OPC's request to have vendor intrusions reported, and I think that based on the definitions of information technology, operation technology, and particularly smart grid system, which is a system or network that enables a utility to gather and store personally identifiable customer information. If a third party is doing that on behalf of the utility, that's still the utility. They become the utility's agent, and therefore it would have to be reported. So if there were an intrusion into a third party vendor that held that kind of data, it would be my interpretation of this regulation that that absolutely would be reported. So therefore, I think that's already covered, at least in the way that I read this regulation. And I think that BGE at least appeared to agree with me in Mr. Ackerman's comments. So with respect to that OPC's point, I agree with it, but I think it's already covered. I think we also have the ability, and do on occasion, ask for additional reporting and additional discussions with utilities. So I think at a minimum is also already covered. And so therefore, I just wanted OPC to understand that we all up here on the bench have, appreciate your comments and appreciate the suggestions, but I think they're mostly covered already in these regulations. Thank you, Mr. Chairman.
Thank you. Commissioner Linton.
Thank you, Mr. Chairman, and good morning, everyone. I had a couple of questions. I guess it will depend on who would like to answer, but my first one is in section 02B2, the definition of good cybersecurity practice. And the definition references what I'll call a phrase of accepted industry cybersecurity standard. Can someone help me understand what that is, and is it something that's documented somewhere, or is it who's read it, who writes it, etc.?
Commissioner Linton, John Borkowski for staff. I'd like to take that question. One of the lessons learned that we had from the first 3-year audit cycle is not every utility uses the same standard for assessing their cybersecurity maturity, et cetera. And in general, utilities are using the NIST standard for cybersecurity. There may be utilities that use the Department of Energy C2M2. But we also have to keep in mind that these regulations are being proposed, that all utilities in Maryland adopt the standard. And there are other standards out there. For instance, you might ask yourself, what about the small water companies? Well, there are standards out there from the American Water Works Association that apply to small water companies under 3,000. So I think the beauty of the good cybersecurity practice definition is it provides that flexibility for utilities to apply the standard that is appropriate to their situation.
So are we convinced or comfortable then that for whichever standard a utility adopts as the one they'd like to follow, that that standard is the appropriate one for them, or perhaps I should say the most aggressive standard, as opposed to a utility selecting one that may fit within their computer system for the moment?
Well, we do, as you know, the commission supervises the utilities, and certainly I think the commission would have an opportunity during a briefing, you know, to question the particular standard, you know, why the rationale for a particular standard that a utility is using. I think we do have to recognize, however, that utility cybersecurity, particularly with Maryland utilities, that are, let's say, part of a larger entity, a holding company, you know, for instance, you know, just using Exelon as an example, you know, you have cybersecurity being managed across various multiple states. And when it gets to a standard for a particular operating company, I think, you know, the operating company cybersecurity is being managed corporately, and it's the best practice for that particular corporate entity. But I do think that, you know, it's a question that can be asked during the periodic cybersecurity briefings about the applicability of a standard. But I do not recommend that you know, we go to anything that's prescriptive. I think we need to let the utilities have the flexibility to adopt a standard, particular standard that's most applicable to their situation.
Okay. Thank you, Chief, for that answer. So just to be clear, then, there's not the work group didn't anticipate that the commission would pre-approve a standard or adopt a standard for a particular utility, either during the course of reporting or at some point before or after?
Yeah, and to be specific, you know, if you look at the NARUC cybersecurity manual, there are questions in there that utility regulators may use to drill down on, you know, what particular standards a utility is utilizing. So I think, you know, our overall guidance here, you know, our recommendations are to keep the reporting framework. The commissioners certainly have a lot of tools available to them from NARUC to be able to question utilities, not only on this aspect, but on other aspect. But I definitely feel like, you know, these are, I think the framework we're recommending here allows for that type of questioning.
All right. Thank you, Chief. Moving to section .04. This is the area where we've established a periodic reporting for all utilities that have 30,000 or more customers. As you know, certainly as you know, and I'm sure many of the work group members know, there are a lot of utilities in the state that are smaller in terms of customer count than 30,000. And I'm sure, as the work group also discussed, the smaller companies oftentimes, unfortunately, tend to be more targets for cybersecurity attacks. Certainly the larger companies get more volume of attacks, but the smaller companies may have greater challenges in maintaining up-to-date systems in order to keep it secure. So what type of monitoring did the work group envision the commission would conduct for the utilities that have less than 30,000 customers?
Okay. At the present time, we had not recommended below 30,000. And this is basically, we're trying to address the cybersecurity plans of the major utilities. We had a lot of discussion in case 9492 about what this particular threshold should be. If you recall, we originally proposed a limit of 40,000 customers, but we lowered it to 30,000 customers because of commission feedback that wanted to have NiSource and Columbia Gas included. I think when you look at all the other utilities in the Maryland, you raise a good point that there is no regulatory requirement being proposed for those particular utilities, but that does not preclude the commission from requesting that a particular company come in and give a periodic report. And I would suggest that if we had a significant breach report involving one of these smaller utilities, that may be an appropriate action. But at this point, we're not recommending that we go below 30,000 customer threshold.
Okay. So did the work group discuss any type of effort to reach out or provide any kind of lessons learned to the utilities that have less than 30,000 customers, or if that number was a smaller number, even for companies that were smaller than that? I mean, certainly there are some utilities in Maryland with hundreds of customers that are still regulated. So did the work group consider lessons learned or best practices types of information that could be made available to some of these smaller firms?
Commissioner Linton, the smaller utilities in Maryland have been made aware of the fact that we are proposing these regulations and did have the opportunity to comment. And I have, sent them to all the water system contacts as well as the gas system contacts. So I would say that although none of the smaller utilities participated directly in the work group proceedings, they are aware of this proceeding.
Okay, no, I certainly, I don't doubt that that was the case, Chief. I'm more concerned about, and specifically just asking if the work group thought about ways to help those smaller utilities that may not have a direct reporting requirement, but still have systems that could be vulnerable to some type of malicious attack, so that there's at least some effort to make sure they are aware that they need to, I don't know, apply the patches that their software requires. Things of that sort that where they may not have active IT departments that are regularly participating with them.
Okay. Commissioner Linton, thank you for that clarification. I would say that the work group itself has not done any work in that area, but in my role leading the work group, I am the recipient of various information either through NARUC or even the Maryland Fusion Center, MCAC, and when appropriate information about securing assets of a particular threat come along, I do pass that along to all the utilities, including the water utilities. As an example, just last week, we forwarded some information from MCAC to all the utilities. So we are keeping them aware. I know in the Pinellas County, Florida water system incident, for instance, we advised all the water utilities in the state of the situation and also what the recommendations were, for water utilities coming from that incident. So we are trying, to basically keep in touch with those smaller utilities, and we provide appropriate information, or we provide information when it's appropriate.
Okay, good. Thank you, Chief. That's what I was hoping to hear. I knew I would hear, but thank you. I guess my last question is more of a, I have to find the section. Just a second. Okay. Section 04B. I know a couple of my colleagues have asked the questions about this section already. I'm just curious if the work group discussed. The section already gives the commission the opportunity and the authority to seek additional cybersecurity reports in the event the commission chooses to do so. I'm curious if the work group considered the types of scenarios that it thought would be appropriate for the commission to say, oh yes, this is a situation where we should have flexibility like this for the commission to say additional reports are necessary. So I appreciate that it's there, and I think it does address some of the concerns that have been raised earlier. But I'm curious if the work group thought about what specifically was the work group interested in, and why was that section included?
Okay. Well, thanks for the question. I do know that we had a lot of discussion on this in the original work group proceedings, associated with case 9492. And at the time, the rationale for the 3-year cycle was based on the NERC SIP audit cycle, the NERC Critical Infrastructure Protection Audit Cycle of the transmission utilities. I think the rationale we had was if NERC is not auditing these utilities on a more frequent basis, that probably is a good standard for us to adopt in Maryland. But that does not preclude, doing something more frequently, which is, why that specific clause was there. Now you would ask yourself, what would, and you did ask, what would trigger something more frequently? I would say that if we had a significant breach and we determined that, ad hoc that we needed to bring utilities in, that would be an appropriate trigger. There may be other triggers, but I do think that the 3-year is a minimum. And I think that any other more frequent reporting is at the discretion of the commission. I just feel like, as experience dictates over time, we may want to revisit that, but I think it's shown to be an appropriate, regulation proposal, at least at the present time.
Okay, thank you, Chief. Just one final question under 04C, and it may be more of a comment than a question, where the utility reporting provides an authorized company officer. I'm assuming by officer that the work group meant an executive, someone at the company that can actually bind the company to the report itself, and that was more my interpretation of the section. Unless I hear someone tell me I'm interpreting it incorrectly, I'll assume I'm correct.
Commissioner Linton, during the first audit cycle, I've been requesting VP level or above certifications. This is a carryover from the advanced meter infrastructure, the AMI requirements. If you recall, the commission has been dealing with cybersecurity for many years, and essentially with the AMI cybersecurity requirements, for the companies that were putting in AMI systems, the commission required in the previous order that utilities provide certification of their reports, and we felt that that was a good idea, and we kept it, and that's why it's there. But specifically, what officer? To me, an officer is VP level or above, and that's, as you say, somebody that can attest to and bind the company if necessary.
Well, thank you, Chief. I think we're on the same page on that. Thank you, Mr. Chairman. That's all I had.
Thank you. Commissioner Richard.
Thank you, Mr. Chairman, and I think all the questions that I had have been answered. But I just wanted to pick up on a couple of I think points that were made today. First, I fully agree with you. This is a very good first start, and I think it's been important to note that this commission and the industry and our staff. I look out at Morris Rhyme. I think when I first got here in 2016, within the first 20 minutes of my arrival, the first thing I did was walk over to BGE headquarters and had a cybersecurity, and that was 2016. So I think we can report back to the president that this commission has been on this for quite some time. But as a first start, I think it is important that we look at both flexibility and also where we might want to possibly in the future look at maybe more formal direction. Commissioner Linton brought up one point that I noted, and that is the reporting requirement for utilities that serve fewer than 30,000 people. Even an attack could be very consequential on if you even had 10 or 100 customers. So I think the point that was brought out at that point that we need to make sure that we're reaching out to these utilities and giving them best practices, and possibly having something in the future we might consider to ensure that all Maryland citizens that are served by a utility that we regulate are being looked out for and cared for. And I think there's some other important things that, as I noted, there's been great cooperation between staff, industry, and OPC. And I think it is vital to make sure that as cybersecurity issues, as this whole area just continues to evolve, that we do look out for customer data. We do make sure that we're doing all we can to protect, again, those citizens. I mean, it's just the last year, I was one of those fortunate ones with Maryland state government that had people apply on my behalf for unemployment and other types of benefits, and so that's very personal to me. My last employer, Westinghouse, I was also a victim of identity theft by a foreign state actor, and then was at Department of Energy, the attack on OPM. So these are not trivial issues, and I think it's important that we make sure that, again, for utilities that we regulate, that we're doing all we can to ensure that we're looking out for customer information and their safety, and make sure they don't have to go through all the steps to get their lives secure. And I think OPC also brought up other important areas that, again, I hope the utilities aren't going to slam the door now or turn their back on future consideration of more formal processes to again ensure that the customers are being looked after. I think it's good that we have that catch-all good cyber security practices, but at some point we may need to ensure that we have maybe a more formal process there. So anyway, again, I think a lot has already been brought up, but again, I do hope that this work group process continues, and that all parties will continue to cooperate and be open to, again, what may happen after this first good step that we're taking today. So thank you, Mr. Chairman.
Thank you, Commissioner. Commissioner O'Donnell.
Thank you, Mr. Chairman. Chief, couple questions. I'm glad you didn't put these reporting requirements into Subtitle 7 and call them out in their own Subtitle 6. I think that's important. But my question becomes then, is there anywhere else in Title 20 where cybersecurity is addressed? Are you aware of anywhere else that it's addressed?
Thank you, Commissioner O'Donnell, for that question. I personally am not aware of any other regulation that currently exists related to cybersecurity, but I will make note that there are two separate areas of regulation under development now where we are going to be proposing regulations that impact cybersecurity. In fact, one of these proposals has already been submitted to the commission approximately 2 weeks ago on behalf of the RM3 Reliability Standards Working Group. We made a filing with the commission, and although it's a very voluminous filing addressing a number of different reliability topics, we did for the first time propose a resiliency regulation in that filing. And although the scope of resiliency is a lot broader than cybersecurity alone, it does specifically mention cybersecurity as requirement that the utility have certain resiliency plans, including cybersecurity. So I would say, you know, we'll have the opportunity, hopefully this summer, to discuss the resiliency regulation proposal in more detail. The other area where we're working on cybersecurity is with the interconnection work group, the PC44 interconnection work group, and we have been working on proposing a cybersecurity regulation related to DER. So we did have some discussion of that in our phase 3 report that we submitted last May, and we're anticipating in the next couple of weeks we'll be submitting a phase 4 report that addresses more fully DER cybersecurity. But I will just make note that the industry standards on DER cybersecurity are not exactly finalized yet, so that is problematic for our efforts. But that's, you know, something we can just, you know, hopefully discuss more when those proceedings, you know, are scheduled.
All right. Well, thank you for that. I just, the importance of this topic and the consequences of failing in this topic, and yet the only thing that in our Title 20 that addresses the topic directly is a 2-pager on reporting. Just is a stark piece of evidence to me that maybe we haven't chronicled or memorialized enough of our expectations with regard to our rulemakings regarding cybersecurity, because nothing here. This is 2-pager on reporting, really, a couple definitions, you know. But
can I address that?
Sure.
I think that if you recall, the original charge from the commission was for cybersecurity reporting, but the work group in its proposal of a good cybersecurity practice regulation actually goes beyond cybersecurity reporting because it requires utilities to follow good cybersecurity practice. So to some extent, you know, we crossed that threshold from reporting into actual, you know, requirements beyond reporting. So I just want to make that nuance, or it may, or more clear, I guess.
Yeah, I appreciate that, Chief. It just doesn't seem like there's much meat on the bones here, but just an observation of mine. Let me ask you this. I've always been confused ever since our good friends at Chop Tank Electric went to self-owner regulation instead of coming under our purview. It's never been clear to me what of our regulations apply to them and what do not. Does this subtitle 6 apply to Chop Tank Electric Cooperative?
Okay. Well, maybe Mike Dean can answer that, but better than I can. But I will note that I think Chop Tank has also been aware of what we're doing, and I think Chop Tank, you know, to the extent that they don't fall under commission regulation, they have been interested in what we've been doing in the past, particularly even with the reliability regulations that we just proposed, because they may elect to put this into their tariffs. So, but
Yeah,
Mike Dean would be more appropriate to answer the legal question.
My question is not as much about awareness on their part or what they're doing, but jurisdictional authority we might have to enforce should they not report if they do come under this. So that's really what I'm asking. And there seems to be some very important stuff in our regulatory construct that should still apply, and I think there are, to Chop Tank Electric. I don't think they're completely, totally divorced, because we've seen them since they've voted to do this. But maybe Mr. Dean can help me out. And then I'm going to do a follow-up with you, Chief, on does the potential exist for an attack in a smaller company like Chop Tank, which is not completely small, it's not a muni, and covers a large geographic area. Could an attack in that kind of cascade into the surrounding utility, like Delmarva Power and Light? Is that possible if they're not under these regulations? And so, Mr. Dean, and then Chief Burkowski.
Well, under Chop Tank's statute, where they became self-governing, it was very specific as to what they were required to follow. Of course, we could always invite them to participate in any of our working groups and conferences.
Yeah, we could invite them, but what you're telling me is we have no enforcement jurisdiction.
Well, I'm not going to tell you that we don't have any enforcement. As long as they cooperate with the enforcement,
Of course.
it's just that the statute, was as passed, has a lot of areas on it that I would disagree with, but it's the statute that was passed.
Yeah, I just there are some portions, I think, of Title 20 that still apply to Chop Tank, but I'm hearing that this one does not, based on the statutory construct of the bill they jammed through the legislature. Is that right?
Well, it's perhaps at some point the scope of their self-governing can be addressed again if issues do come up.
Okay, thank you, Mr. Dean. Chief, my question about cascading, should an attack occur in Chop Tank Electric to a surrounding utility and start taking large parts of our grid down? Is that possible?
Commissioner O'Donnell, I feel like that question is probably something that, and first off, I do not know the answer, but second, I do think that that would be something that would be what we would call in the industry multiple contingency scenario if it would ever happen, meaning a lot more things than one thing would have to happen. But in any case, if there were likely scenarios like that, that would be something that would not be appropriate for public discussion.
Well,
So
I need to understand what the potential is here. Like, for instance, even a muni, get away from Chop Tank Electric. Could a muni take a large utility down if they got attacked? Is there cascading potential?
I would say in general for any utility, and based on my experience, there's always the potential, but it's usually only if other things happen that were not intended. For instance, when the Northeast blackout occurred back in 2003, it was just a small transmission line, but that cascaded because of multiple failures of protective systems and things like that. So I would say that, in general, not specifically to this Chop Tank situation, but in general, there are things that potentially can cascade anywhere on this system, but there's multiple layers of defense, and if and you would have to have several misoperations. I do think that all the regulations that we have particularly in the transmission area, because you're talking about a situation in Chop Tank cascading up to the transmission. But with the multiple regulations and SIP requirements and things of that nature, I would say it's very unlikely. But I could never say never.
All right, thank you for that. Maybe we can continue this discussion offline at some point so I can learn more about it. Thank you.
My thanks to all the parties for participating on this very important rulemaking, along with the efforts of the reporting work group over the past few years. At this point, I would propose to my colleagues and move that the Commission publish the following draft regulations as proposed by staff on March 1st, 2022, as modified by staff on March 25th, 2022, in the Maryland Register for notice and public comment, subject to non-substantive changes necessary to conform to COMAR drafting requirements, and that is with respect to Title 20, new Subtitle 6, Chapter 1, Regulations 1, 2, 3, 4, and 5. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved, and these draft regulations, will be published in the Maryland Register. With that, this hearing is adjourned.